afternoon, everyone, and welcome to today's LegalVision webinar, Redundancies and Restructuring, Understanding Your Employer Obligations. And please feel free to scan the QR code and download our guide at any stage. We'll put that up again shortly. I'm your host, Mike Mullins, and we're very lucky to be joined today by our Senior Associate, Louise Miao. Before we begin, just some quick housekeeping. You will receive a recording and the slides in your email, so feel free to take notes if you wish, but don't feel like it's frantic. We will send that to you afterwards as well, and then submit your questions in the Q&A box below, and we'll do our very best to answer them at the end. And please, if you would, complete our feedback survey after the webinar. It's really helpful. And don't forget, you are eligible to claim a complimentary legal consultation with us by viewing the webinar today. That's where we can jump on with a consultant to discuss how LegalVision can help your business moving forward to navigate those various legal requirements, which are different for every business. To claim, it's easy. Just leave your contact details in the survey that appears when the webinar ends, or contact us via the website.
Perfect.
Fantastic.
Thanks, Mike.
I'll throw to Louise, our expert. Enjoy, everyone.
Thanks, Mike. So today I will be giving a quick introduction to restructures and redundancies and the process of a restructure, how the consultation process works as part of the restructure process, before moving on to what a genuine redundancy is and what the risks are when you terminate employees as part of a restructure redundancy process. And then we'll go through a Q&A. So just for a quick introduction, restructures and redundancies relate to more than a process and legal framework. Obviously, you do need to consider your legal responsibilities as per legislative frameworks that are in place, but you also do need to consider any moral and ethical responsibilities around employer duty of good faith to your employees and also during the process. A restructure and redundancy process can be stressful, so it is important to ensure that you are meeting your legal obligations while ensuring your employees' well-being. So, what is a restructure? A restructure is when an employer makes significant changes to how their business is set up and operates. This may change reporting lines, it might combine or eliminate teams or departments, it might be a reallocation of work and responsibilities. So this organizational change can often lead to positions becoming redundant if a role is no longer required or if it's being done differently within the new proposed structure. And then what is a redundancy? So a redundancy occurs when an employer no longer requires an employee's job to be done by anyone. So this means the position itself becomes surplus to a business's requirements. And it relates to a role becoming unnecessary, and it's not in relation to their performance or any misconduct. So what is the process of a restructure? A restructure must follow a fair and reasonable process, keeping in mind your employer good faith obligations. So I will go over the general process of a restructure before speaking more in depth to the consultation process. So firstly, the proposal. So before you announce anything to any staff, you should be planning a proposed restructure. So this involves identifying the business reason that drives the potential change and developing a proposed new structure as opposed to the original organizational structure. You do need to determine which roles may be affected, regardless of whether that is just a minor role change or whether it is a full disestablishment of the role. And then you need to also plan accordingly for the timeline and the process. So when announcing the proposal to staff, you must inform employees as early as possible that you are considering a restructure. This communication should essentially explain the business reasons for the change, outline the new proposed structure, identify which positions might be at risk or proposed to change, and then explain the consultation process and timeline to the employees. Employees should also receive this information in writing with a clear statement that this is a proposal and not a final decision. And then moving on to the genuine consultation. So once you've given the proposal, you enter the consultation phase. Consultation must be genuine and must be meaningful. It's not just a formality. So employees must be given adequate time to provide feedback on the proposal, suggest alternatives to what you've proposed, and also raise concerns. So the time frame for a large-scale restructure is usually around 2 to 4 weeks for the consultation period, but it can be shorter if maybe only one or two employees are being affected. Employers should be meeting with affected staff, genuinely listening to their concerns and suggestions that they make, and keeping an open mind about potential changes to the proposal that employees suggest. Obviously, employees can bring a support person to these meetings, and also if they don't opt for a meeting, you can have them provide written feedback if that's what they prefer. So the employer must genuinely consider all feedback that is received, and you must seriously evaluate any alternatives that are suggested. If you do take on any suggestions or need to change the proposal, essentially you do need to start back from the proposal stage again and redo the consultation period. Exploring alternatives. So throughout this process, you must actively explore alternatives to redundancy. So what this means is things like redeployment, potential voluntary redundancy, if that is something that is being suggested, or something like reducing hours instead of eliminating positions. And then once you've finished your consultation period and have your feedback, this is when you make your final decision. So after the consultation closes, you consider all the feedback, and then employees are notified in writing with confirmation of whether their role is potentially being disestablished, the reasons for that decision, and any notice periods or severance arrangements. So again, severance arrangements are in the employment agreement. And then lastly, we've got the selection process. If this is applicable, not all restructures to redundancy have a selection process, but if you choose between employees for a similar role, you do have to have a fair and objective selection criteria, which includes looking at skills, qualifications, performance history, and experience. So the criteria must be applied consistently across all of the employees that are affected, and it cannot be discriminatory. So what I mean by that is how much sick leave someone might have taken, or their age, how long they've been in the business, anything that doesn't actually relate to the role itself. And it should be an objective measure. So just to go into depth about the consultation process. So once you have provided employees with the proposal, you'll be in that phase of consultation. So usually this means you need to gather the feedback and give staff enough time to consider the proposal, seek legal advice, give feedback if needed, and then you must ensure that you also provide employees with enough time to get legal advice and provide that feedback. And if employees request additional time to get that legal advice, you should also do so in good faith. And then once that feedback has been provided, you need to genuinely consider that feedback. A good way to do this is to write down reasons of why you've accepted or did not agree with the suggestions that they've made. And the way to provide the response to feedback essentially does differ case by case. So if an employee raises issues that relate specifically to their role personally, you might opt to have a separate meeting, like a one-on-one, to provide their response personally. But where feedback is more general and doesn't identify a specific employee, that might be something that you opt to collate into one feedback questions and answers document and send that off with the final decision. Again, if you will be taking on any feedback as part of the consultation period, then and it substantially affects the overall proposal, the best and most effective way to manage this is to essentially start from step one and issue a new proposal that incorporates that feedback. If you will be proceeding with the original proposal, then you will need to confirm the new structure, and this needs to be done in writing and in a meeting, and then obviously implement the change. There is no set time for this process to take place, although usually somewhere between 4 to 6 weeks is ideal. So the time frame, again, can be less or more, provided it meets the legal test of what a fair and reasonable employer could have done in the circumstances at the time and considering the resources that were available. You may also need to consider things such as annual leave, public holidays, when assessing the time frame for a consultation period. So employees also do need to be given reasonable time to consider the proposal, seek advice, and provide that feedback. And then you also need to demonstrate that you've taken time to genuinely consider the feedback before making that final decision. So from an HR perspective, you should be communicating to all. So it's not just the impacted staff. Staff will be talking about the restructure regardless of whether you want them to or not, and that tends to create a lot of unease within a team. It's better to have employees understand that a restructure is happening and not need to provide feedback than completely not include them. It's also important that you have ongoing communication with affected staff. So it's not a one-time communication, here is the proposal kind of situation. You should be building in follow-up communications, check-ins with the affected employees. It might be one-on-one, it might be within a team. And then obviously plan feedback response communications. And then once you've done all of that, you do have to genuinely consider the feedback and have a feedback management system. So that might be discussing and accepting and using feedback where it's relevant, or providing feedback to employees if they've given some. And then obviously updating impacted staff and general staff with the updated proposal if relevant, or confirmation of the proposal and plan to go with the final decision. So what is a genuine redundancy? So a genuine redundancy occurs when an employer no longer requires an employee's job to be done by anyone. So this means the position itself essentially becomes surplus to a business's requirements. It is crucial to understand that the redundancy relates to the role and not a specific employee's performance or conduct. So for a redundancy to be genuine, there must be a real business reason, which might be financial factors, might be decreased work volume, or it might be a closure of a business or part of it, like a department or a team that's no longer required. So the work that was being done must essentially no longer be needed, must have decreased substantially, or essentially will be eliminated through the organizational change. If the work continues to exist after the redundancy, or if someone is hired to do substantially similar work shortly after, this often raises serious questions around whether the redundancy was genuine. So under New Zealand employment law, even where redundancy is genuine, you have to follow a fair process, which includes that consultation, exploring alternatives, and also acting in good faith throughout. So a restructure process should not be used, again, for unsatisfactory or poorly performing employees. Termination is the last option that you should be considering, and you should be looking at other options before termination. So that's things like redeployment or reduced hours. And then you should obviously genuinely consider the feedback from employees during this process. It's also important to note that there is no statutory entitlement to redundancy compensation in New Zealand. So any redundancy payout will essentially depend on what you've included in your employment agreement. And if it's not in your employment agreement, there is no entitlement to it. You can obviously opt to add more if you choose to, but there's no entitlement for it. In regard to the risk of terminating employment. So if an employee wishes to legally challenge the redundancy, they must do so by raising a personal grievance. This needs to be done in writing within 90 days of the termination. So in most cases, a personal grievance will be based on some sort of alleged unfairness in the process, such as a predetermined outcome. So in some cases, a personal grievance will be based on challenging an employee's justification for the restructuring. For example, incorrect financial information. So I've referred to the Grace Team accounting case, which is quite a landmark case. So in this case, a restructure process was initiated due to incorrect financial information. The company wasn't aware at the time of doing the restructure, nor through to the redundancy, that the information they relied on was incorrect. So obviously the employee was subsequently made redundant based on that incorrect financial information. And then she raised a personal grievance. So this case went all the way to the Court of Appeal, where it was found that it wasn't enough just to follow a fair process in the redundancy, but they do need to be justified on correct factual information and genuine reasons, which the company didn't meet. So if a personal grievance is pursued, it usually results in a settlement or mediation. And then if it doesn't result in a settlement at mediation, it normally goes to a hearing at the ERA. So that's the Employment Relations Authority. And again, if it gets appealed, it will either it will go to the Employment Court and then Court of Appeal or even the Supreme Court. The time and stress and legal costs associated with defending a claim is quite considerable. And obviously, the company name is public once anything is in the ERA, because all the determinations made there are public. So that is something else to consider. So again, from an HR perspective, the main risk is reputational and brand impact from unhappy employees who discuss their experience after employment ends. So redundant employees will often talk, feel disgruntled, feel negative, which creates a stressful environment for remaining employees who may wonder, will my role be at risk of, a redundancy in the future? Will I lose my role as well? It often makes staff feel very vulnerable due to the situation. They can feel angry and spiteful. So obviously in this situation, you need to show care and actually have genuine employee well-being mindset and approach into consideration. So that's why it's very important that you genuinely consider the feedback and have open communications throughout. And lastly, obviously, if you have EAP support for any employees, that should be offered as well. And I will just pass back to Mike. That's okay. I think Mike's internet may have cut out, so I'll just continue on. So essentially, that does conclude the main part of our webinar. So you might find our publication useful. It's the How to Hire and Inspire guide. You can scan the QR code on screen there. Otherwise, it will be in the resources tab as well. We also do have a webinar on the 9th of December at 12 o'clock. So that is in tips to help your business avoid going to court. Highly recommend joining that one if you find that interesting. And in terms of membership, so we're going to answer your questions shortly. And while you submit them, we'll just take a minute to tell you about our LegalVision membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and also unlimited domestic trademark registration and much more. As a LegalVision member, you don't have to worry about the cost of lawyers ever again. So essentially think of it as having your own in-house counsel. We'll take care of the business as usual legal work so you can focus on running your business. We can also offer a dedicated service for in-house teams and general counsel to manage high volume business as usual legal tasks. Our lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function.
And thanks for that, Louise. And on that team, I'd just like to say it's worth doing, even just to build out, your legal planning timeline for the years ahead. So feel free to take us up on that. And to claim, just complete the survey at the end of the webinar.
Yep, perfect.
And now let's go to the exciting part, the Q&A. I know we've received a ton of questions, so Louise is the expert. Jump into it.
Perfect. So I'll just give you guys a bit of time to answer, to submit your questions. I do have some pre-submitted ones that came through in advance, so I'll go through those ones first while I give you guys a bit of time. So the first one is, can an employee challenge the restructuring? And if so, what grounds would there be to bring such a challenge? So, short answer is yes. An employee can challenge a restructure through the personal grievance claim, as I discussed earlier. So, common grounds include procedural unfairness, inadequate consultation, insufficient notice, or failure to genuinely consider feedback. Another one is substantive issues. So, a business's rationale isn't genuine, or a restructure is essentially a sham to target specific employees. Um, the third one is disadvantage. So essentially, if the restructure process disadvantages an employee, so say, for example, an employee might be on maternity leave or parental leave, or if there's any other protected grounds. And lastly, the selection process. So the criteria or application was essentially unfair or discriminatory. So that's, again, things like age or if they've taken too much sick leave or something like that. So as we discussed earlier, employees do have 90 days to raise a claim. The next question I have here is, do I need a lawyer in my business decision making? So this is a bit more of a general question. You don't necessarily need to have a lawyer in every single decision you make. A lot of decisions that you make are commercial decisions. But from an employment perspective, when you are going through a restructure, it's always best to engage with a lawyer to ensure that you have the correct steps and processes in place to make sure that you are complying with the law and you don't end up with a PG. The next question is a two-part question. So I will just answer the first one and then go on to the second one. So the first one is, how long do you need to wait for feedback after proposing a restructuring that is going to take place before you can confirm it's going ahead as proposed? Very good question. There's no fixed time frame that you have to meet. It will depend on how many employees the restructure will impact. So if the proposal will result in one or two roles being made redundant, you might just opt for a 5 to 10 day feedback period. But say, for example, a restructure affects 30 or more people, you might need to take a couple more weeks to ensure that everyone has enough time to go seek the legal advice and give feedback. And if people want to have one-on-one meetings, that you've captured that time and put into consideration. So after that entire process is done, you would obviously need to provide your responses to their feedback alongside the decision if you're going ahead. And the second part of that question was, how do you show that you actually tried to redeploy the employee to another part of the business? So in terms of redeployment, if there are active roles that are being advertised in the business, those should be offered if they're relevant to the employee in the first instance as part of that restructure. If it's a role that the employee will need to upskill on, that is still something that you do need to take into account and assist the employee in upskilling if they choose to take on that redeployed role. If it's a role that's available that is completely different from their existing role and they can't actually perform the role, or it's just completely different, then you can also say that there are no redeployment opportunities available. You can always say, we have these roles open, but we've identified that they're not suitable for your position. The next question I have here is how to do the selection process when a number of the same roles are being reduced. So when you reduce multiple identical roles, you do need a fair selection process. So this is establishing objective criteria, so ensuring that you have developed clear job relevant selection criteria. So that's things like skills, your qualifications, performance, experience, potentially things like client feedback. Again, obviously we avoid discrimination or any criteria that may come across as discriminatory. So that's things like age and how long you've been in the business. With the criteria, it's always a good idea to weigh it. So have appropriate weighting to each criteria that you have. So you might assign more points to, say, for example, performance over qualification, if that's more relevant for that specific role. and you do need to ensure that you apply it consistently. So you do need to assess all affected employees against the same criteria. So you can't have one employee assessed on one set of criteria and another employee assessed on a different set. And obviously, it's very important to document everything, record how each employee was being assessed. If an employee asks to see their score, you should be giving that to them. Obviously, you shouldn't be giving any other employees' scores, but you can give them a range of where they're sitting in relation to everyone else. And then lastly, it's important to consult on the criteria. So when you do that proposal, you should have the selection criteria included as part of it. And so that allows affected employees to provide feedback on whether they think the proposed selection criteria is fair and before it is applied to them. And the last question here is, what if restructuring is a result of another critical aspect and mostly external? So that's a really good question. External factors are valid for restructures. For example, if you didn't land a certain client and there's suddenly no need for an entire team or a particular role as a result, that's a very valid reason. Most of the restructures that we actually deal with are due to loss of clients that lead to a financial downturn, or the decision to close down a specific department because there's just simply not enough work to keep the department open. I would need a little bit more of context as to what critical aspects you're referring to, but typically if it is an external factor, it is usually a valid reason. And then we've got one question that's come through. So if a team is moved to another state, that would be considered redundancy, even if the employees are offered to relocate. So in that situation, what you would need to do is go through that proposal to say that you are relocating. And if you are relocating, essentially, they can be offered that role in the new state. If they choose not to take it, then essentially, yes, their role would be made redundant. The next question I have here is, can an employer use restructure to reduce employee hours? Should that apply to all employees or can it be applied to one employee only? So any restructure that only applies to one employee usually looks a bit of sham contract, not sham contract, sorry, sham restructure to redundancy. It's usually preferred to not go down that route. However, if you are a small business and you do need to reduce hours, that is something that you can do through a restructure, even if it does affect only one employee. You do just need to be aware that it is possible, and we can't always stop the claim of an employee raising a personal grievance. I think that might be all the questions that have come through for now. I have actually had a number of questions come through also regarding leasing and sales of business. Unfortunately, I can't assist with those questions on the webinar today, but we do have the free consultation that Mike mentioned earlier, and you can discuss your questions more in depth with one of our team.
Absolutely, Louise. Take us up on that free consultation, which you are completely eligible to claim today by watching the webinar. So we always love chatting to business owners to help them plan for their upcoming legals. So book that in with us. Just leave your contact details in the survey after the webinar or contact us directly through the website. We'd love to chat to you in more detail. And thank you very much to Louise for her expertise today. That was very brilliant, a topical one. And we'll see you all at the next webinar. Thank you, everyone, for attending. Goodbye.
Thank you.